defense.
Okay, Ms. Rivadeneira, here's my concern. We have some text messages on January 8th, and here Ms. Molkoy said, I'm not in a good place physically and mentally to basically sign for the bond. I'm really sorry. I'm dealing with a lot of stuff right now. I'm not in a place to co-sign on this bond. I'm willing to lend you the money, but it's not responsible for me, with all my other responsibilities, to go ahead and sign on this bond. After she sent you that, why did you push her?
I was desperate, and because we'd spent several days together because she had just had a surgery and I was helping her, taking care of her, and we were friends, and honestly,
and she loaned you the money, and then she said, but asking me to co-sign on this bond is just one step too far.
But she's the one who offered to do it in the first place. I didn't ask her to do it, she offered to do it.
And why would she do that? Why would she put everything she had up?
Because she believed in me, I'm not sure.
Okay, Ms. Molkoy, did you ever approach the defendant and suggest that you actually co-sign on the bond?
No, I didn't.
Judge Corriero.
So the way I read this case is very simple for me. I'm going to put aside this issue of who forged whatever name. Fact is, your friend was being sought by a bail bond company and was in danger of losing $2,000 because of the behavior of your boyfriend. So where is your boyfriend? Is he still your boyfriend?
He's not my boyfriend anymore.
Good, good. It's quite clear to me, when you were in need, she gave you money. What do you do for a living? Are you a finance manager?
No.
No, it was $2,000 that you saved, your hard-earned money. She gave it to you, right?
Yes.
Whatever is said in these text messages is meaningless. Fact is, she gave you a substantial amount of money, and she's worried about it because you said that you would pay it once you got a loan, and the loan fell through. You're a caretaker.
Yes.
People who are caretakers should have a sense of empathy, of heart, right? Do you have that?
Yes.
You feel their issues? Do you feel the pain that you caused your friend?
I do.
I have nothing further. The parties are excused while we deliberated.
Okay, so this is pretty simple in my eyes. You got a friend who was willing to give another friend money for someone she doesn't know, and she owes her the money back. Listen, I wouldn't even sign an attorney's bond for my client. It's too dangerous. I can understand why the plaintiff wouldn't want to do it.
And it pained her not to do it. I mean, she wrote this long text, I'm so sorry,
Right.
but I can't take it a step further.
She did enough.
She did more than enough.
More than enough. She's got to pay her back.
I think she really doesn't feel that she even has a defense, but she's trying to do her best to rationalize brushing her off over a period of time and making her feel even worse. I mean, it's clear that she got the money, she used it, and it's clear that the obligation still stands.
All right, well, we've got a verdict.
Yes.
This court is again in session.
This is a pretty open shut case. Ms. Molkoy, you let the defendant here, Ms. Rivadeneira, borrow $2,000 with the understanding that she would pay you $2,000 back.
Right.
Ms. Rivadeneira, you don't deny that you owe her $2,000. I think the moral of today, though, is that we've got to appreciate when friends show up for us. And your friend here showed up for you. Despite her issues at home, her own troubles, she gave you $2,000 to bail out your boyfriend, someone that you're no longer with. And not paying her back, for whatever reason, is just irresponsible, but you're not being a friend back. For her to do that and really put herself in jeopardy says a lot. And it's just a shame that this friendship, I'm not sure if it's repairable or not, but I can understand that there are going to be trust issues at this point. So the verdict of the court is that you pay the plaintiff $2,000. And that's the court's verdict.